Mr. Richards.
My Lords, I appear with Miss Suri for the appellant. My learned friend Mr. Pennington Benton appears for the respondent. My other junior, Mr. Ramdeen, apologises for his absence. He's unable to be here due to...
Yes, could you arrange that his inability to obtain a visa is intimated to our registry? We have made strong representations to the authorities about this, and we're concerned that this is occurring, and we will take up that matter with the authorities. Thank you.
My Lords, the Court of Appeal in my submission made two errors which justify the intervention. An error of appellate overreach, wrongly substituting its own view of proportionality for that of the system, and an error in suggesting that brief fee for counsel cannot ordinarily. These errors, my Lord, are significant, not because of the result in this particular case. Costs that turn on them are about $80,000. They are significant because a failure of appellate restraint only serves to encourage cost appeals, thereby increasing the burden upon litigants. And because what the Court of Appeal says about counsel's brief fee is expressed in general terms and is liable to have an impact on future cases. The respondent to this appeal, for her part, does not maintain any suggestion. And that is welcome, it is helpful and appropriate. But the suggestion is nonetheless there on the face of the Court of Appeal's judgment, and it ought to be corrected.
Well, you'll take us to the relevant passages which yes, you say
I will.
Generalise the prohibition of brief fees beyond the brief fee for the trial.
Yes, Lord. I intend to make my submissions, I hope briefly and in four parts. First, to show your lordships the relevant rule and practice guide applicable to the assessments of costs. Secondly, I'll explain the materials that were before the Assistant Registrar. Third, I shall seek to demonstrate that the approach of the Assistant Registrar was unimpeachable. Finally, and against that background, I shall address the errors made by the Court of Appeal. What I shall not be making, my Lords, is any Ladd and Marshall application.
No, we had an intimation to the effect that you weren't doing that. Thank you.
Nor, to be clear, shall I be making any submissions about the principle in Openshaw. As we said in our written case, ground 5 of appeal is not pursued. Openshaw was not mentioned by either of the courts below, and it's irrelevant to my case on this appeal.
Thank you.
So I begin then with the approach to the assessment of costs. It's governed by Part 67 of the Civil Proceedings Rules, and in particular by Rule 67.2, which is at page 688 of the bundle. The core rule for inter partes costs is paragraph 1 of Rule 67.2. Where the court has any discretion as to the amount of costs to be allowed to a party, the sum to be allowed is that the amount that the court deems to be reasonable, where the work to be carried out by an attorney at law of reasonable competence and which appears to the court to be fair, both to the person paying and the person receiving such costs. The touchstones are reasonableness and fairness as between the parties. Paragraph 2 of Rule 67.2 deals with attorney-client costs with which we're not concerned. Then paragraph 3 provides that in determining what would be reasonable, the court must take into account all the circumstances, including the matters there set out. The Chief Justice, my lords, has issued a practice guide to the assessment of costs. It was issued in 2007 and begins at page 712 of the bundle. Your Lordships will see on page 712, under the heading, the approach to the assessment of costs, a number of principles set out. These include, in point 3, a principle of proportionality, and I'll explain the source of that proportionality principle, which isn't, of course, in Rule 67.2 in a moment. Turning on to page 713, there is at paragraph 6 of the practice guide an explanation of the approach to assessment on the standard basis, which is, in effect, the same as the approach to standard basis assessment in England and Wales.
So you say that's the same?
Yes, my lord. Paragraph 8 on page 713 explains where proportionality comes in. The concept of proportionality was given paramountcy by the overriding objective in Part 1. And it's because of the overriding objective under these civil proceedings rules that proportionality is an additional touchstone alongside reasonableness and fairness as set out in Rule 67.2.
And just for our notes, can you tell us where the overriding objective comes in? What's the rule?
It is, I'll need to check the precise rule in Part 1, my lord.
I imagine it will be familiar.
Yes.
Yeah, I'm rather assuming all of these rules are very familiar to people operating within the Trinidadian court system.
Yes, my lord, and I ought to be able to give you the number off the top of my head, but I apologise that it escapes me. I'm grateful to Ms. Suri. It's actually just within Part 1, the overriding objective. It's at page 897, your Lordship's note, set out in the judgment of the board in the case of Bergen and Evans. Hang on, no, that's the wrong. I apologise. That's a wrong reference. My Lord Sales, if I may, I'll return with the correct reference.
Of course. But I presume we can take it that it also is going to be similar to the overriding objective in the England and Wales.
Yes, my lord, it is.
DPR.
That's what I meant by familiarity, that they probably modelled that on English and Welsh.
Very much so, my lord. And we'll see now at paragraph 9 on page 714 that the practice guide expressly adopts the approach to proportionality in the assessment of costs explained by the Court of Appeal of England and Wales in the Lowndes case. Namely, a twin approach of considering proportionality both globally and on an item-by-item basis when going through a statement of costs. If we move on to page 716, in paragraph 19, the guide addresses the approach to counsel's fees in terms which, again, are familiar. The guidelines laid down in Simpson's motor sales are approved. The proper measure of counsel's fees is to estimate what fee a hypothetical counsel capable of conducting the particular case effectively, but unable or unwilling to insist on the particularly high fee, sometimes demanded by counsel of preeminent reputation, would be content to take on the brief. The practice guide envisages that counsel will be paid a fee on brief, a brief fee. And if we move on to page 718, paragraph 25, the guide gives the sensible reminder that in assessing counsel's brief fee, it is always relevant.
Sorry, where are you?
I'm sorry, my lord, page 718,
Yeah.
paragraph 25. In assessing counsel's brief fee, it is always relevant to take into account what work that fee is intended to cover. The well-known English case of Loveday and Renton is cited, and the guide endorses the familiar list in Loveday of items which will ordinarily fall within a brief fee. But Loveday, to be clear, does not suggest, and the guide does not suggest, that counsel can only charge a brief fee when they are doing all this work. It's never been the case in England or in Trinidad that to be able to charge a brief fee, counsel must be preparing cross-examination notes, working during the evening, advising experts at weekends, conferring with experts without separate instructions. The point made is that if you charge a brief fee, those items would be expected to be included within it.
But presumably the amount of a brief fee will to some extent reflect the extent of the work which is intended to be covered by it.
Absolutely, my lord, yes. And that's why paragraph 25 begins that in assessing the brief fee, it's always relevant to take into account what work that fee, together with any refreshers, is intended to cover.
Well, that seems to be completely uncontroversial. I cannot see any basis for a brief fee which didn't take account of the likely work that was to be covered. I come from a jurisdiction where we don't have brief fees, so I look on this concept with interest.
My lord, that was my first topic. The second topic is the materials before the Assistant Registrar. There were two key documents. And to answer my Lord Sales's question, it's Rule 1.1 in Part 1, the overriding objective.
Thank you.
So there were two key documents before the Assistant Registrar.
And sorry, do we have it in the bundle?
We don't.
No, okay.
The first key document was the Appellant's amended statement of costs dated the 26th of October 2020, which is at page 44 of the bundle. And the substance begins at page 45. The way this works is that the statement of costs begins with a schedule of costs, item by item, all of them numbered. And then from page 58 onwards, there are submissions seeking to justify and explain the costs claimed. In particular, at page 60, from halfway down the page, there is an explanation and justification of the principal brief fee claimed of 138,000 TT dollars.
I'm sorry, where is it?
Page 60, in the middle of the page.
In the red? That was the amendment, was it?
Yes, my lord. So the original statement of costs did not explain or justify in any detail the brief fee.
And in the original statement, do we see the brief fee amount claimed then?
Yes, we do. So in the original version, we have the brief fee itemised at page 50. In items 13 and 14, there were two brief fees charged for the two applications, one being the substantive habeas application, and the other being the application to treat the substantive application as fit for vacation, business and urgent. But what the amendment did was to explain the basis for the principal brief fee and what it covered.
You said item 14
Item 14 and item 13, my lord.
and 13.
And what does that, I'm looking at item 13, what does that mean? To deem fit 5 hours with an uplift of 10 hours?
So there were two applications. One was an application ancillary to the habeas corpus application to deem it fit for vacation, business and urgent hearing.
Ah, right, okay.
The uplift is expressed in hours, but is an argument that a higher fee is justified because of the circumstances of the case.
And so, and 14 then is the fee for the application?
Yes. So that's a fee of 138,000 calculated on the basis of 60 hours. The value of 60 hours work is how it's calculated.
When did counsel get instructed in this case?
Counsel was, well, we see that from, one can pick that up from the statement of costs. Counsel's brief is drawn on the 10th of April, page 45, item 2. Drawing brief to counsel. And then on page 46, there is a conference with counsel, that's an advocate attorney at law, the same day. But the brief fee for the hearing is not incurred until we see on page 50, the 15th of April, 5 days later, which was 2 days before the hearing ultimately took place.
Sorry, that's page 50, do you say?
Yes, ma'am.
Yes. Well, how does one claim for 75 hours of work in items 13 and 14 on that timetable?
Well, my lord, the registrar said that it was an exorbitant fee and
Right.
And slashed it accordingly. But of course, a brief fee is, among other things, compensates counsel for devoting himself entirely to one case at the expense of other work. So that is a matter to be taken into account. But well, I don't quibble with that. The brief fee was, in the judgment of the assistant registrar, exorbitant, and she responded appropriately to that.
I mean, it's almost abusive, frankly, to put in fees at this level for a habeas corpus application.
Well, my lord, what I do accept is that the fees were wholly disproportionate, unfair and unreasonable to recover on an inter partes basis.
Yes.
I don't accept that they were abusive with respect.
I wouldn't expect you to.
The Court of Appeal, notably, the Court of Appeal suggested that there was no issue with counsel charging his client a brief fee of this kind. The Court of Appeal,
Well, that wasn't before the Court of Appeal.
Well, no, my lord. Anyway, you have my response to
Yes.
your lordship's observation about abusiveness. But to be absolutely clear, my lord, I must accept and do accept that the original fees claimed inter partes were unfair, unreasonable, and wholly out of proportion. That's what the registrar said, and nobody has challenged that. The issue on this appeal is whether there was any basis for the Court of Appeal to interfere with the Assistant Registrar's decision.
Right.
So,
I'm just going through the itemised list. I mean, counsel charging the things that one might ordinarily think would be included in the brief fee.
yes,
Like
Lord.
a series of conferences, and preparing his written submissions. These are all being charged as additional elements.
Yes, my Lord. And counsel's brief fee was very heavily reduced by the Assistant Registrar.
Right. But, I mean, since counsel seems to be charging for all the things that are covered by the brief fee, one is left wondering whether any brief fee at all.
Well, my Lord, I can deal with that. So I was about to come with what the brief fee covers.
All right. I'm conscious that I asked you to show me the itemised list. You haven't. I invite you to break off from page 60. Did you want us to read that?
So what I was going to show your lordships is the explanation of what the brief fee covers, which conveniently answers my Lord Sales' question.
Yes, all right. So shall we read the red text?
Well, I just ask you to note first, my lords, that it begins with a recitation of paragraph 25 of the practice guide, which your lordships have just seen. And then the relevant bit begins at the bottom of page 61. The fee on brief in this matter comprised the following. And there is a list which sets out exactly what the brief fee in this case was intended to cover. So, point 1, consideration of how the court would exercise its discretion. Point 2, effectively, advice on the application and advice on evidence. Point 3.
What point 2? Advice on evidence.
It's described as considering the application for permission, as well as all supporting documents, for the purposes of determining if there was any evidential difficulties or gaps that had to be filled.
But isn't that what would be discussed at conference?
Yes, my Lord. There's clear overlap. I entirely accept that. And so 1 and 2 certainly overlap with matters that have already been dealt with at conference. But then there is 3, which is effectively legal research. And again there, I accept there's considerable overlap. But then 4 and 5.
Right. But sorry, I mean, let's just identify what the overlap is. Presumably that's the overlap with drafting and preparing the submissions for which a separate charge was made. Is that right? You yes, said there's an overlap. Is that what the overlap is with?
Yes. Well,
right.
Not only that, my Lord, but there is a specific charge in item 5 for...
Sorry, page?
Oh, sorry, page 47. I'm sorry, my Lord. For legal research.
Right.
And there is a specific charge in item 6 for advice on the merits of a public law challenge. So when counsel is preparing for the hearing, and that's what this brief fee covers, it's absolutely right to note that he will already have considered, in the course of his previous advice, these matters. And that's the basis.
I mean, one can keep going. Item 7, drawing pre-action protocol letter. So that's the letter to assert the claims for which a separate charge is made. And then drawing the application itself, that's item 12. Sorry, the one that I had in mind, in fact, was... Yeah, item 37, page 54, drawing full written submissions. Oh, sorry, that's on the issue of costs.
Yes,
I'm so sorry.
Item 37 is on the issue of costs. Although, whilst we're looking at item 37, it's a convenient moment to flag that this is a mistake, because in fact, in the appellant's case, there were not full written submissions on costs, because the appellant relied upon her mother's submissions in the related case of Caura Ramsaroop. So that was a mistake. It's actually a mistake which the respondent made before the assistant registrar as well. But I flagged that. It wasn't drawn to the assistant registrar's attention that, in fact, the appellant had just relied upon her mother's cost submissions.
Right. When you say it's a mistake the respondents made, it's not surprising, because, I mean, they're just going to go on the information provided by the applicant, aren't they?
No, my lord, because the respondent, and I can show when we come to the respondent's objection, the respondent referred to the appellant having produced cost submissions and said that they were, the fee for that should be knocked down. The respondent knew perfectly well that cost submissions hadn't been produced. Both parties served notices, two-line notices, saying we rely upon the cost submissions in the other case.
Right. Anyway, you would explain to us where the overlap was with matters in the brief fee. So I've noted down item 5, item 6.
Yes,
which other items are the overlap?
Just before we leave, sorry, my understanding was that items 36, 37, 38, 39, it's all conceded that they shouldn't have been charged.
Absolutely.
Because they were going to the mother's case.
Yes, ma'am.
Same submissions. But that's not an issue anymore.
That's not an issue. The only point for your lordship's purposes is that that's not a matter for which the assistant registrar can be criticised, because as the Court of Appeal recorded, it wasn't pointed out to her that the party just relied upon their submissions in the other matter. So, my lord,
And one of the big points generally, is it not, that the Court of Appeal was making, was all this research, etc., was in any event being incurred for the mother's case.
Oh, yes, my lord.
So there's massive overlap there.
Well,
I mean,
it's a big point, which, as I'll show your lordships, which the assistant registrar made, because she was perfectly alive to this point and slashed the claim costs accordingly, partly on that basis, as I will show your lordships. But for present purposes, I would like to focus on what I would call the absence of overlap, in some respect, of counsel's brief fee to what has already been done. Of course, standing back, counsel still has to prepare for a hearing. So counsel has to consider the matters itemised in the schedule, even though he has already done the work previously, so one would expect him to be able to consider it much more quickly than he would otherwise. But then in paragraph 5...
Yeah, but I mean, also the compression of time is relevant
yes,
on those.
I
Not like
accept that.
the counsel going to have to go away and remind himself of these things. He did it yesterday or
Indeed, my lord.
today.
And one of the points that the assistant registrar made was that this application ultimately turned out to be a non-starter. The whole thing lasted only 2 days. So that's very much a point which the assistant registrar had in mind. And I am, to be absolutely clear, in no way seeking to challenge or go behind what the assistant registrar said. My point is that there was no basis to interfere with her decision.
I see the point you're making, but it is very striking what has been done in this case when you look at the charges made in respect of the mother's claim, where there's a similar brief fee of £138,000. And when you think of the provisions to which you've referred us in the rules of the CPR about reasonableness, fairness and proportionality, it is an astonishing set of circumstances.
My Lord, what I would say to that is that the Assistant Registrar took that into account, and that's why she took an axe to the statement of costs. What she didn't take into account, my Lord, Caura Ramsaroop's statement of costs, because that was never put before her. Just to be clear about that, but absolutely she took into account the other case and questions of duplication and so on. The point I wanted to make in relation to item 5...
Can I just be clear about that? You're saying that the first instance judge, the assistant registrar, did not take account of the overlap with Caura Ramsaroop's case?
No, my Lord. She took account of the overlap. What she didn't have before her was the statement of costs in Caura Ramsaroop's case.
So she could only take account of it in a very general sense.
The reason for that, my Lord, was that for whatever reason, the respondent, director of the Caura Hospital, chose not to put that statement of costs before the registrar. The first time the statement of costs in Caura's case has been relied upon in these proceedings, in the appellant's case, was when it was included in the evidence accompanying my learned friend's written case before the board. The assistant registrar can't be criticised for not having had regard on a line-by-line basis to those costs.
But perhaps your client could be criticised. I mean, doesn't your client have to approach the court in terms of justifying his fees with a level of candour? And it was known that there was an issue as to the degree of overlap with the mother's case. Wasn't that clear?
Well, my Lord, with respect, it was perfectly candid. My client's attorney was perfectly candid in what was being claimed because it was set out in a statement of costs, which in each set of proceedings was served upon the respondent.
All right.
And it wasn't for my client to argue the case against herself in relation to costs when the respondent was amply and ably represented with the full resources of the state.
When did you say it first became relevant, the actual amount of costs being claimed on the mothers?
I think you were saying that the mother's claim for costs, which is attached to the respondent's case here, only came before the board.
That's right.
But the Court of Appeal was aware, paragraph,
Yes.
I saw it a minute ago,
Paragraph
29, they were aware that Mr. Ramdeen had been awarded $149,194 for the mother's case.
Yes, that's right, Lord.
But without a breakdown of how that had been made up.
That's right. The registrar was aware, as we'll see, at first instance, that there was this other case described by the respondent as a carbon copy of...
So what is it you're submitting she didn't know? You mean she knew the overall figure but not the breakdown?
No, that's the Court of Appeal figure.
Yeah, but are you saying she knew nothing about the figure?
No, my Lord, I'm submitting that she can't be criticised for not, in her judgment, having made reference to the detail of the statement of costs.
Did she know at that stage what the overall figure was?
It isn't mentioned in her decision, and it isn't mentioned in any of the materials that were before her. So my inference would be no. But that's I should make it clear, my Lord, that is an inference from the materials that are in the record.
But you might say, well, the Court of Appeal had fuller information before it and therefore made what appears to be a 50% reduction for disproportionality now that it's got the information in front of it. What's wrong with that?
What's wrong with that is that, my Lord, a discretionary assessment of costs and the appropriateness of it has to be assessed on the basis of the materials that are before the first instance judge. That is a matter of basic principle. You can't as the director of the Caura hospital, go to the Court of Appeal complaining that the assistant registrar failed to take account of the final costs award in the related case, when you, the director of the Caura hospital, were well aware of that because you were the respondent in that case too, and didn't draw it to the assistant registrar's attention.
But this is a case of responsible counsel making a claim for costs against the state in circumstances where he must have known just as well as the hospital what had happened in the mother's claim. Is that not right?
That is right, my lord.
And where is there any mention of in the assistant registrar's judgment of the sums that were awarded to the mother?
There is none, my lord.
There is none. So you can't just rely on burden of proof and say it was for the hospital to bring it up.
I don't know.
Counsel is putting forward a claim of what he is asserting is fair and reasonable, or counsel and the instructing attorney. And no mention was made of the fact that there was that the attorneys had already been awarded $149,000 in a parallel claim. I mean, was it being treated as irrelevant because of reference to old English case law? Was that the explanation?
Well, there certainly seems to have been reliance upon that principle below, my lord.
Yes.
But I don't rely upon that principle before the board.
No.
What I do say is this, that it should not be forgotten that the award in the mother's case was for the mother's costs. It was not an award made in respect of the appellant's costs.
No, of course not. But the same urgency, the same novelty, all those considerations which were played in aid in the daughter's costs would have been claimed in the mother's case as well. So I mean, there's blatant duplication here.
Well,
and it's not as though your client and her counsel were taken by surprise before the assistant registrar. So I'm looking at paragraph 18, page 75, paragraph 18 of the assistant registrar's judgment, and she says that an objection made by the respondent was this piggyback element. Now, I think you would say, well, they had the itemised schedule of costs in the Nailah Ramsaroop case, and so they could have put it forward. But given that they themselves were drawing attention to this piggyback element, couldn't it be said that a responsible counsel with precise information about what had been involved in the Nailah Ramsaroop case and what was being claimed by way of costs in that case, should themselves put that before the court so that the court could make its judgment on what was an objection being taken by the respondent?
my lord, I don't accept that it was a point which the appellant was required to take against herself.
No.
In circumstances where...
my point is, it's a point being taken already against her, so she doesn't have to take it against herself. It's just a question of equipping the assistant registrar with the information that would be necessary to assess the validity of the point being made.
Well, what is clear is that neither party, neither the appellant nor the respondent, thought that it was necessary, in order to equip the registrar with what she needed to make a decision, to inform her of the award that had been made in the other case. And that is what both parties thought, rightly or wrongly. What I can also say is that if there was a failure...
Okay, sorry, can I just ask one point of detail? Had the award of costs already been made in the Nailah Ramsaroop case by the time of the hearing before the assistant registrar?
By the time of the hearing, yes, my lord.
Right.
but not at the time the statement of costs and the respondent's objections were put in.
Right. Okay.
It did, I think it was in October 2020. I'll be corrected if I'm wrong about that, Caura Ramsaroop assessment. Oh, I'm grateful to my other friend, Mr. Pennington Benton. 14th of December 2020, I'm told.
Was the award of the mother's costs?
Yes.
14th December 20.
Lords, my answer had been to Lord Snails. The first part of my answer was that if it was a failure, it was a failure by both parties.
Yeah.
The second part of the answer is that it isn't illustrative, and I really must say this, particularly in Mr. Ramdeen's absence, since he isn't here to speak for himself. It can't be illustrative of any lack of candour on his part, because in fact the appellant, Mr. Ramdeen, positively relied before the Court of Appeal upon the award in the other case. They sought to set up the existence of the award, which was unappealed, and there's a reason why it wasn't appropriate for the respondent in this case.
So in what way did he rely before the costs judge on the award in favour of the mother? And where do we
Before the
see
Court
that?
of Appeal, I said, my lord.
In the Court of Appeal?
Yes. And we see that on page 241. Paragraph 29.
Yes, the argument is, well, the state's allowed it in one case. It's inconsistent not to allow a duplicative claim in another case.
And this argument is rejected, and I don't challenge the rejection of the argument, but Mr. Ramdeen himself was the one who brought up the existence of the other award in support of an argument that he made. And I just make that point in fairness to Mr. Ramdeen.
Yes, in fact, that paragraph suggests that he put the figure before the court.
Yes, although, I mean, it does have to be pointed out, that's in support of an argument that he himself sees fit to make in the Court of Appeal at that time. So it's when it suits him, he puts it before the court.
Well, my lord, for whatever reason, it suited both parties, both the respondent and the appellant, to proceed before the assistant registrar on the basis of their statement of costs and objections thereto, without drawing the award in Caura Ramsaroop's case to the assistant registrar's attention.
Yes.
My lords, I was on points 4 and 5, I think, in page 62. No, the page is wrong, but let me give your lordships the right page. So pages 64 and 65. We're back in the explanation of what counsel's brief fee was intended to cover. Point 4 is consideration of the respondent's evidence. Now, this was, as your lordships may recall, evidence which was served in draft on the 17th of April, on the day of the hearing itself. And then point 5, counsel had to read the authorities which the respondent proposed to rely upon. We see on page 66 the list of authorities totaling 90 pages, which the respondent's counsel had sent across to Mr. Ramdeen that morning. So, although I accept there was duplication within the brief of matters which, of work that had effectively already been done, or at least prepared pretty extensively, counsel still needed to prepare his submissions and to consider, among other things, the late evidence and the authorities relied on by the respondent.
And you remind me, what was the respondent's case? I can see the respondent's difficulty in relying on provisions which relate to the detention of people coming into the country as a basis for detaining a citizen. So the state was perhaps batting on a difficult wicket. But what was the respondent's evidence on the 17th in a nutshell?
In a nutshell, it was that new law had been made, and the relevant laws are set out
Yes.
in points 1 and 2 of the authorities. These were new coronavirus regulations which authorised the detention of a person in the appellant's position. That was the legal basis for detention, and the evidence was, in a nutshell, that the appellant was being served or had been served with a notice under the new regulations which effectively regularised the position.
So the essence of it was to understand the terms of the new regulations and ascertain whether they had been served on the appellant.
Yes, my lord. And to understand whether, as the appellant ultimately accepted because she withdrew the claim, whether they meant that the claim, the application, I should say, was no longer viable.
Well, if the new regulations were effective, then the state had a complete answer to the writ of habeas corpus.
Yes, my lord. And that's why, very responsibly, the appellant drew her claim, and then there was an argument about costs.
And the inference that we draw from the fact that the costs did not go, in a sense, with the successful party, contrary to the normal rule, is because the inference, the initial detention was unlawful, and it only then became regularised. Is that what's going on there?
There is.
I mean, why have we got a reversal of the normal rule?
There is a decision on costs of Mr. Justice Rahim, which explains why.
Thank you. It's at 394 and following, I think. Yes.
Yeah, 395.
Because there was an application for costs on an indemnity basis, I think.
That's right. So Mr. Justice Rahim refused the application for indemnity costs, but so I'm very grateful to my Lord Hodge.
So it's para 626. I think. I don't think he tells us precisely why.
Well, paragraph 26 is a summary of the matters which the judge has discussed in the preceding paragraph.
Yes, I mean, what he seems to be saying is that faced with the letter before action, the hospital knew a challenge was coming, and they did nothing to make it unreasonable for the appellant to continue with the challenge up to the point when the regulations were made and the state's position was regularised. think that's the essence.
That's right, my lord. The appellant's argument was essentially, if you had only said, I accept that the quarantine regulations don't provide authority for your detention, but the government is in the process of bringing in new COVID regulations, which will regularise it, then it would never have been necessary to make an urgent application.
Well, I fully understand why the learned judge came to the view which he did on that point.
Just to complete the picture on what's covered by the brief fee, there is, unsurprisingly, nothing about preparing cross-examination notes or the kinds of things you would expect in a full trial. This was a brief fee for a habeas application and the preparation thereby required. And, the second key document.
Sorry, just a point on item 5 on pages 65 to 66, which is reading the authorities relied on by the respondent. In fact, most of those are covered by the work involved in the research for the claim itself. One sees a duplication, for instance, from item 1, Van Heerden, Administrator of JS Morocco, and so on, and item 3, provisions of the Constitution and the relevant legislation.
I accept, my lord, that counsel will already have been familiar with some of the materials in the respondent's list, because he considered them. I don't accept that he'd already read most of them. But
right.
My lord, I'm just going to identify, in the interest of time, the second key document, rather than take your lordships through it. It's the respondent's objection, and it begins at page 444 of the bundle, with the substantive objections starting at page 452, in paragraph 18. But all I flag for your lordships note that the respondent specifically relied upon the fact that the appellant's mother had brought carbon copy proceedings, paragraph 28, page 455, and there was at page 460 to page 463 an attack on the brief fee.
Which pages again?
460 to 463, my lord. But there was no argument that a brief fee was inappropriate. It was that, in the circumstances, a brief fee of worth no more than 2 hours' work should have been awarded. And there was no argument, quite understandably, no argument that you shouldn't be awarded a brief fee on a habeas case because there isn't a trial. So those were the materials before the Assistant Registrar. Her decision begins at page 71 of the bundle. Paragraph 10 and following on page 73, she correctly directed herself as to the proper approach in law, and the respondent has not identified any error in that self-direction. Then her analysis begins on page 75, starting quite correctly at paragraph 17 with a global assessment of proportionality, and she held, as she was entitled to, that the sum claimed was unreasonable, unfair, and highly disproportionate in the circumstances. And in that regard, she specifically accepted that the key points made by the respondent, that the application for a writ was a non-starter, that the appellant could piggyback on her mother's case, and that the whole proceedings lasted only 2 days. The Assistant Registrar then embarked upon a line-by-line analysis, which is summarised in paragraph 22 of her decision. And as she explains at paragraph 23, in conducting that analysis, the registrar specifically had regard to, first of all, the close similarity of the case to the previous matter, Caura Ramsaroop's.
But this is page 79.
79, yes.
Item 1, yes. Subpara 1. Yeah.
So, and because of the fact of Caura's case, less time should have been spent on the appellant's case. Point 2, the assistant registrar dealt with the brief fee. She noted that the total brief fee claimed was $172,500. She considered on page 80 what was said in Loveday. And then on page 81, she concluded, and quite appropriately concluded, that the applicant's attorney at law was entitled to fee on brief. This matter is one which would have required the advocate attorney to prepare work before the delivery of the brief and satisfy himself that he should accept it. It would have inevitably required evening preparation and consultations between members of the team of counsel, and the counsel would have to address his mind to chronology of matters. But what was claimed in terms of hours and sums was excessive and exorbitant. And so she slashed the total brief fee to 40,000 or so. Not quite decimated, but more than quartered. And then at item 3, the assistant registrar accepted certain arguments about duplication. And having done that in paragraph 24, the assistant registrar took a step back, looked at the figure that resulted from the line-by-line analysis, 125,770, asked herself, was it fair, reasonable, and proportionate, and concluded that it was. Now, my lords, the assistant registrar's decision was, in my respectful submission, unimpeachable. She followed the well-established approach required of her. She considered the points that had been drawn to her attention, and she reached a decision that was well within the reasonable range open to her. As I've said, there was one matter.
Well, sorry, isn't that the point on which the Court of Appeal said that she had gone wrong in principle because she'd gone outside the reasonable range open to her?
Yeah, that will be one of the errors that you say you're coming to.
Right.
Just to, there is one matter missing from the assistant registrar's judgment, which I should flag, and that is the point I've already noted, that neither party, or both parties, had missed the fact that the appellant had not produced her own cost submissions. And that's paragraph 16 of the judgment of Justice of Appeal Budu Singh.
So
that's not an issue on the appeal.
Para 16.
On page 234.
Right, so I'm
That's
not...
the point. It's accepted on both sides.
It's a point that's not an issue.
Right.
That's items 36 to 39.
Yes, my lord. And I stand by the submission that the registrar's decision was unimpeachable, because the error that was made was the party's error, not her own. So against that background, my lords, I shall address very briefly the errors made by the Court of Appeal. It is, of course, well established, and it's common ground for the board. The Court of Appeal should only interfere with the discretionary assessment of costs if the first instance judge has erred in law or in principle, or has reached a decision which no reasonable court could have reached. And we've cited the authority of Singh and the Public Service Commission at paragraph 19 of our case.
Right. Are you saying that the Court of Appeal misdirected themselves on that?
I'm saying, my lord, that they ignored that principle.
So you are saying they misdirected
Yes,
themselves?
yes.
All right.
Well, we set it out, but then you say it didn't apply it.
We'll see how, if I may, I'll show you
Yes,
each of the errors in turn.
Yes, take us through what you say are the errors.
So the first relates to the suggestion that it was wrong in principle to award any brief fee. And it's important to note that because the Court of Appeal said it was wrong in principle to award a brief fee, that's suggesting a recognition perhaps that they had to identify an error of principle in order to interfere. The relevant passage of the judgment begins at paragraph 19. Reference to on page 237, reference to the case of Loveday and Renton. Where it was stated that the brief fee covers the preparatory work for the trial, attendance on the first day of the trial. And perhaps the seeds of confusion may here be sown by the reference to a trial. In paragraph 20, the Court of Appeal describes the nature of a habeas corpus application in terms which are not controversial on this appeal. Paragraph 21, this case followed the usual course with some nuances, describing the conduct of this case. And then at 22, the nature of this habeas corpus application, as for most such applications, did not require a trial in the normal way. In this case, the application was withdrawn, hearing lasted 15 minutes, and the issues were almost identical. In principle, therefore, the incidence of a brief fee ought not to have arisen in this case, as it would also not ordinarily arise in a habeas corpus matter. So that is a holding that in principle, don't get a brief fee in a habeas corpus case in the ordinary run.
And that seems to be a consequence of their, what they say in paragraph 20, where they describe the ordinary way in which a habeas corpus application would be prepared, which seems to squeeze out the sorts of things that you would expect to be covered by a brief fee.
Yes, my lord. And I can be absolutely clear about this. If we were only talking about the appellant's particular case, there would be no point of more general importance worth troubling the board with. But what the Court of Appeal say in terms is that in principle, the incidence of a brief fee ought not ordinarily to arise in a habeas corpus matter. And therefore, at paragraph 23, the Court of Appeal says, the issue the Assistant Registrar had to consider was whether it was fair and reasonable for the appellants to have to pay the costs of a fee on brief where there was no trial, in the usual sense of the word. And reference is made to the particular circumstances of this case where there was duplication and so on. The Assistant Registrar erred in determining that it was appropriate to make an award for a fee on brief. So the fee on brief is disallowed in its entirety. My lord,
Right.
Well,
But, I mean,
there's a slight ambiguity about brief fee, is there not? I mean, the advocate is still getting all the costs of research, preparing, and all that sort of thing. So it is the brief fee. Now, what on your submission is meant by the brief fee in a situation where you're already getting time spent on research, submissions, etc.?
well, my lord, I don't accept that in this case the appellant's counsel was already getting all the necessary time for preparing hearing. But really what matters is how this is liable to be interpreted in future cases. Because on the face of it, in paragraph 22, the Court of Appeal is saying you don't get a brief fee in a habeas corpus case because you don't have a trial, and that is
Yes, but this is a decision of Court of Appeal of a jurisdiction, and they're saying we don't want brief fees to be charged in these circumstances. Why can't counsel not have itemised charges for the time spent doing the preparation which would otherwise be covered by the brief fee? I mean, is there any objection in principle to a jurisdiction saying, well, we're not allowing brief fees for this sort of application, but we're not saying that counsel can't charge time and line, as it were, for preparation for such a hearing?
Well, my lord, there wouldn't be an access to justice problem.
Yeah.
I accept that, of course. There might be a discretion problem in that Rule 67.2 requires that regard should be had to the circumstances of the particular case in assessing the sum that is fair and reasonable, and to establish a general rule that a lump sum fee isn't appropriate risks fettering that discretion.
Except it said ordinarily, isn't it? Yeah. This would not ordinarily arise in a habeas corpus matter, so the discretion is preserved even on their formulation.
But what the Court of Appeal is not here saying is that counsel can be remunerated on an hour's charged basis.
But they're certainly not ruling it out. Certainly in Scotland, where I come from, where we don't have brief fees, even if it's a trial, we account our preparation hour by hour, and it doesn't mean that causes an access to justice problem. Where, in principle, is there an objection to a jurisdiction saying, in this sort of application, there won't be brief fees? You have to itemize your preparatory work.
My lord, as a matter of principle, absent what the rules say in 67.2 about the need to consider particular circumstances of every case, there wouldn't be an objection. It's not fundamentally objectionable. I can't make that submission to require fees to be charged on an hourly basis. But, my lords, it has to be understood that the practice guide, which dictates the hourly rates, presupposes that brief fees will be charged. We've seen, my lords, that when it comes to consideration of counsel's brief fee, it's envisaged that a brief fee will be charged. And if you have a system without brief fees...
But can you not ask for an hourly uplift? I think we saw in the claim that there were various examples where claims had been made that X hours had been done, but X times 2 was requested in the circumstances of the case. Wouldn't that be a perfectly flexible way of adapting adapting to the circumstances of the case? What was a fair charge?
The difficulty is that the Court of Appeal hasn't spelled this out, and as it stands, we have a bald statement that a brief fee ought not to have arisen in the case and would not ordinarily have arisen in a habeas corpus matter.
Yes, they're setting up a general rule that in habeas corpus you don't charge by means of brief fee. But there is still an enormous flexibility within the rules to which you refer, the 67.2, in terms of reasonableness and fairness consideration of all the circumstances and proportionality, for counsel to be satisfactorily rewarded for his professional effort.
Well, my lord, if that is what the Court of Appeal were saying, there would have been no basis to disallow the entirety of the brief fee. Because as your lordships have seen, brief fee covered certain matters, at least, for which counsel was otherwise not remunerated.
Well, you say that, but the Court of Appeal, in their assessment, are saying he has been remunerated. Isn't that the point of paragraph 20, where they go through, is what I was putting to you before, that they've really said, when you look at what is required in a habeas application, and you look at what's been charged here, there really isn't left over some sort of brief element which hasn't been fully covered. And they return to that point, don't they, in paragraph 23, where they say there's no trial in the usual sense, so no need for a brief to cover those elements. This is particularly the case where an itemised approach was taken in the assessment, where fees were being claimed for taking instructions, conferences, research, drafting applications, and attending at the hearing. And they've said that's what you need to do for a habeas application, those things, and you've charged for those things. There's nothing in principle left over for that the brief needs to cover.
Well, if that's what they meant, they were wrong, because preparation for the hearing has not otherwise been charged for. In this case,
I mean, he's done the research 10 o'clock in the morning. The hearings, yeah, I'm making it slightly crude, but everything, that's the compression of time is significant here. He's taken instructions, he's researched the matter, he's drafted the letter before claim, he's drafted the application. He doesn't need to go into a darkened room, does he, and conduct further research before he goes into court. He's really done all the research along the way.
I don't accept that at all, my lord.
Right.
On the day of the hearing, no, it's not the darkened room.
Right, okay.
It's that on the day of the hearing, for example, he receives 90 pages of authorities and 3 witness statements. He needs to prepare his submissions to the court and prepare for the potential hearing in light of that material.
Okay.
Which
That's not 60 hours worth, is it?
No, my lord.
And you say 90 days of materials. I go back to the fact he's already read most of those materials by his own account when he was doing the research for the letter before claim and the application, Van Heeren and so on.
And standing back from the cases, the issue was very straightforward. There were these regulations. Had they been served on the client, and did they cover the client's circumstances? I mean, you were earlier telling the board that the brief fee was related to the opportunity cost of not doing other work. I don't really see how that is consistent with the terms of Rule 67.2, where you're trying to fix a fee that is fair and reasonable and proportionate for the actual work being done.
Well, my lord, 67.2 is dealing, of course, paragraph 1 is dealing with recovery inter partes, and we haven't dealt on this appeal with attorney-client costs. Now,
No, we're not concerned.
We're not concerned with those, but it must be appropriate in some cases for attorneys to charge their clients fees which reflect the opportunity cost of devoting themselves to their particular case. And that being so, there must, on an inter partes assessment, be the opportunity to recover brief fees which incorporate an element of that.
Do you get brief fees for what are clearly contemplated to be quick applications? Let's say there's an application listed for half an hour. Good brief fee for that?
Well, my clerks would charge a brief fee for a half-hour application, my lord. that's the practice that I understand to exist in England and Wales. In Trinidad and Tobago, my experience may not be typical because although I'm a member of the bar, I'm not based there. So I can take instructions on my Lord Burroughs' point.
But even in the jurisdiction in England and Wales, sometimes council's rates will be charged on an hourly basis, sometimes on a brief fee basis. There doesn't seem to be any problem in principle about it being said, well, what's reasonable in a particular context is that one charges on an hourly basis for the work actually done rather than on a brief fee basis, where things are sort of left up in the air and one's left to guess whether the work's actually been done or not. But there doesn't seem to be a problem in principle in adopting such approach in appropriate circumstances, does there?
My Lord, no, not a problem in principle. And it may be that subject to that clarification, paragraph 22 is something that my client can perfectly happily live with. But the reason that paragraph 22 has brought us here before the board is a justified concern that, but for this appeal, the state in future cases, future habeas cases, would not be taking the moderate position which Mr. Pennington-Benton very sensibly adopts, but would be saying, see paragraph 22 of the decision in Ramsaroop, you can't have a brief fee for counsel.
Ordinarily,
Yes, ma'am.
it's a general rule.
As a general rule.
Anyway, your other point
The
in
other
relation
error,
to error.
And you have our fuller submissions on this in the written case.
Yes.
The other error relates to proportionality. Paragraph 24, on page 239, refers to the approach suggested by Justice of Appeal Jamadar. That's the reference to the Lowndes case, sorry, that's the Mohammed case, which approves Lowndes in Trinidad and Tobago. It invites the cost assessor to take a step back after an item-by-item assessment and consider whether the overall figure should be reduced or increased. The final sum was 125,000 or so. The parties' positions are considered, and then at paragraph 28, in this case, the assistant registrar ought to have taken a step back after the item-by-item assessment and then consider whether the overall final award ought to have been reduced or increased. To the extent that this was not done, she erred. It falls to the appeal court, therefore, to undertake the assessment. But I've already shown, my lords, the final paragraph of the assistant registrar's judgment, where she did precisely what she ought to have done. And indeed, it ought to follow from paragraph 28 of Justice of Appeal Budu Singh's judgment that because she did what was required, there was no error and there's no basis for the appeal court to conduct its own assessment. At paragraphs 30 and 31, Justice of Appeal Budu Singh held that the assistant registrar ought to have assessed proportionality having regard to the fact of Caura Ramsaroop's case, but she did, as we've seen. The assistant registrar referred to the fact that the appellant's application piggybacked upon her mother's, and she significantly discounted 20 items on that basis, paragraph 23, subparagraph 1 of her judgment on page 79.
Paragraph, sorry?
I'm sorry, 23, subparagraph 1, page 79.
Yes, thank you.
My learned friend in his written case fails to identify any misdirection by the assistant registrar or any relevant matter which was drawn to her attention but which she failed to consider, such as to justify the Court of Appeal interfering. My Lords, unless I can assist you further, those are my submissions. I'm conscious that I've overrun my estimate.
Do not be concerned. That's very clear, Mr. Richards. Thank you very much. The board will adjourn now to consider its position, and we will return shortly.
My Lords, in light of debate before your Lordships this morning, I have instructions to withdraw the appeal.
Well, I think it's important that we give some guidance in this matter. I'm not accepting the application to withdraw the appeal. Mr. Pennington-Benton, we do not need to hear from you. The board will take time to consider their judgment. Yes.
My Lords, in light of debate before your Lordships this morning, I have instructions to withdraw the appeal.
Well, I think it's important that we give some guidance in this matter. I'm not accepting the application to withdraw the appeal. Mr. Pennington-Benton, we do not need to hear from you. The board will take time to consider their judgment.